Hello, thank you so much for having us and coming to our panel. My name is Jesselyn Radack, and I'm the director of the Whistleblower and Source Protection Program at ExposeFacts. And our mission is basically to facilitate investigative journalism by providing free, direct representation to whistleblowers, sources, journalists, and publishers who are facing criminal exposure for telling the truth and for making information available to the public. Our clients have revealed some of the biggest scandals of this century that involve human rights, including torture, secret surveillance, black sites, and CIA drone strikes. For speaking out, they have faced investigation and prosecution under the Espionage Act. Some, like our client Daniel Hale, ended up in prison. Others have, like Julian Assange, basically is facing extradition right now. And then still others, like our client Edward Snowden, are in exile. This is America, which holds itself out as being the beacon of a free and open democratic society, and I don't think most people are aware of the crackdowns on press that are going on in our country. To that end, I am pleased to have this esteemed panel of journalists who can speak very directly to these issues. I have Jameel Jaffer, who is the inaugural director of the Knight First Amendment Institute at Columbia University. I have Sam Lebovic, whose recent book, he's a professor at George Mason University, and he has a recent book called The Espionage Act and the Rise of America's Secrecy Regime, which is really one of the first narrative histories of this incredibly controversial law. And finally, to my immediate right is Jeffrey Sterling, who is a former CIA case officer, including on the Iran task force for nearly a decade. And he ended up serving 2.5 years in prison after being convicted of violating the Espionage Act. He is the author of a memoir called Unwanted Spy: The Persecution of an American Whistleblower, which was published in 2019. I'd like to start with Sam, because you have just written an exhaustive history about this very pernicious law. So if you could give us a very brief background on the Espionage Act, that would be great.
Sure. Well, hi all. It's a great pleasure to be here. So the Espionage Act is passed in the US in 1917, when the US is entering, sort of late by European standards, into World War I. And although it's called the Espionage Act, it's probably better understood as an omnibus national security law. It has a whole host of measures that are designed to allow the US government to effectively wage war during World War I. So it has a classic espionage provision in it, Section 794, that makes it illegal to give secret information to a foreign government, what we would think of as classic spying. But it also has a lot of other measures in it, including one that at the time made it illegal to interfere with the draft, which was interpreted in World War I, basically to say that if you criticized the war in a newspaper or in a public speech, that might make soldiers less likely to turn up and fight, and so you could go to jail for public criticism. And about 1,000 Americans go to jail during World War I for public dissent. In reaction to those sort of prosecutions, actually the US Supreme Court first begins to outline what the modern right to free speech is, and its civil liberties groups like the ACLU begin to organize because of the use of the Espionage Act during World War I. And because of that activism, those kind of explicit censorship provisions fall away over the course of the 20th century. But what rises up in its place is the section we'll talk about today, which is Section 793, which is understood best, I think, as an information handling law. And it's a sequence of provisions that make it illegal to do a lot of things with what's called information relating to the national defense. So you can't disclose it without authorization, you can't retain it without authorization, and so forth. sort of secrecy laws. And there's one basic problem with Section 793, which is that it outlines a whole host of measures to say that you can't do things with information relating to the national defense with people who are not authorized to receive the information. But it defines neither the phrase information relating to the national defense nor any process by which someone would be authorized to receive it. And the reason for that is that originally, when the law was passed, it was supposed to give that power to the president. But the US Congress didn't want to give President Woodrow Wilson so much authority over what information could circulate in public, so they cut those sections out and never replaced them. And this introduced a fundamental ambiguity in the Espionage Act that really has haunted it up until the present day. And so what my book shows is basically a century-long process of evolution and experimentation to make sense of these confusing provisions. I think there's, just very briefly, two things that we need to sort of understand that come out of this history. The first is there's a real evolution in government secrecy practice. And this comes after the Espionage Act was passed. So in the early 1950s, in the Cold War, the US government establishes a modern secrecy system, the classification system, top secret, secret, classified. That comes 4 decades after the Espionage Act, but they kind of lock into each other to give the Espionage Act real reach over the billions of documents that are classified by the US government during the Cold War. The second is there's a long process of conflict, as every time one of those secrets leaks, the US government will try to use the Espionage Act to protect its secrets and to punish those who've disclosed information. And throughout history, it has tried to both prosecute journalists to make it illegal to publish information, and it's tried to prosecute sources for disclosing information to the press. And what's happened over US history, the course of US history, is that the press and civil liberties groups have been very good at using the First Amendment to protect them from Espionage Act charges, but they have not protested or protected anywhere near as much the prosecution of sources for providing information to the press. And that will lead us, I think, into the use of the law during the War on Terror, when there's massive secrecy, and then there are a new generation of whistleblowers, and then it turns out the Espionage Act can be used very effectively to prosecute them.
And this would be a good time to pivot to Jameel, because he can talk about the modern application of the Espionage Act, which had been dormant for a large period of time, but then, as Sam said, after the War on Terror became reinvigorated.
Hi, everybody. I guess maybe one place to start is just with, I think it's a useful exercise to think about all the things that we know now that we wouldn't know if not for whistleblowers. And if you just think about, what we know about the War on Terror, it was government insiders who gave the Washington Post information about the CIA's black sites overseas, and it was government insiders who shared the Abu Ghraib photographs basically 20 years ago today. It was a government insider, Edward Snowden, who disclosed what we know about the National Security Agency's warrantless wiretap activities. A lot of what we know about the Obama administration's drone campaign, we know because of Daniel Hale and many people whose names we still don't know, their decision to share information with the press. And all of that was in violation of the text of the Espionage Act. Just going back to where Sam left off, before 9/11, before 2001, the Espionage Act was used almost never against journalists' sources. Not quite never. There was one case that actually did come to conclusion. Somebody named Samuel Morrison, who gave photographs to Jane's Defense Weekly and a defense magazine, and he was prosecuted and convicted, although he was then pardoned by President Clinton. I think that was the only conviction of a journalist source before 2001, but others will correct me if I'm wrong. After 9/11, the US government began to use the act very aggressively against journalist sources. And it was the Bush administration really that started that process, but the Obama administration picked it up. And I believe the Obama administration is still responsible for more Espionage Act indictments against journalist sources than any other administration. So this is really, a place of rare bipartisanship in the United States. And then, very recently, we have had the first indictment of a publisher under the Espionage Act. Julian Assange was indicted under the Espionage Act a few years ago, and as you all know, the extradition proceedings are ongoing in the UK. There's a possibility that he'll be sent to the United States to face trial under the Espionage Act very shortly. This is a very important line that's been crossed here, because Assange is not a government insider. He is not a journalist source. He's a publisher, and whether you think of him as a journalist or a media figure at all, he is being prosecuted for the publication of classified information, which is something that media organizations and journalists do all the time. So that's really the trajectory.
And I think that's a good segue to Jeff Sterling, because he can speak to what it will actually look like if Assange is extradited here and does face prison.
Yeah, for me, I joined the CIA to serve my country, and then being charged with being a spy, being charged with espionage, a traitor, under the Espionage Act was shocking for me. But I'm a lawyer, and I said, well, hey, I'm going to fight this in court. I don't care what the law is. It's innocent until proven guilty. They had absolutely no evidence that I revealed classified information to a reporter. Absolutely none. But the Espionage Act is such a powerful tool for the prosecutors, Department of Justice to use. I mean, the trial was a little more than theater. They didn't really have to prove anything. They don't have to present their evidence of my guilt. One, there was none that they had. And also, it is a absolute liability law, which means really it's a we say so law. He violated the Espionage Act, we say so, we don't have to prove it. That is the antithesis of innocent until proven guilty. And for me, it was shocking, for my legal training. It's like, what is this process I'm going through? This isn't a legal process. This isn't for justice. This is for retaliation. And all in the name of national security. So the trial became nothing more than theater, a continued character assassination, if you will. The witnesses that they called forth were just other agency employees. And oh, by the way, this was one of the few times the CIA was openly talking about sources and methods in a public court. So they were really just gearing up to go after me, to punish me. And so, they just paraded officers on, even assets they paraded on the stage, which you never reveal an asset to the public, but they freely did to their assets. And so, but using the Espionage Act, they didn't really have to prove anything other than, we say he did it. And being in the Northern District of Virginia, the Eastern District of Virginia, where Assange will be going, the jury pool is completely made up of individuals with current or previous connection to the intelligence community. There's already an automatic bias for anyone who is sitting in that, against anyone who is sitting in that defendant's chair. So again, the theater just continues. And in my case, really, it's like, well, we say he did this, we don't have to prove it. Oh, we're gonna bring on other people to establish how guilty Jeffrey Sterling is. One of the witnesses they called was Condoleezza Rice, who had absolutely nothing to do. One of the perpetrators of one of the biggest political lies in recent memory, being called to tell the truth about an operation she had nothing about, knew nothing about me, but that was just the image. Let's bring up this former vaunted government servant as an example of a good government employee against this bad one. But that's the nature of the Espionage Act. The law had nothing, and the legal process had nothing to do with it.
To pick up on that, I think absolutely right. This was a lot of security theater to punish Jeffrey, but also to make an example out of him. And part of the purpose of the Espionage Act being used is the chilling effect that it has on investigative journalists. And I always said the war on whistleblowers is a backdoor war on journalists. And now we see that coming to full fruition with the prosecution of Julian Assange. But I wanted to open this up to everybody, maybe starting with Jameel, about what the global impact is of using the Espionage Act in this kind of way. For example, right now, Russia is holding an American journalist, Grigorskovich, on espionage charges. So how is this really different from what we are doing with Assange?
Well, I guess, one way to think about the Espionage Act, an accurate way of thinking about the Espionage Act is it's a prohibition on the collection and publication of government secrets. And if you understand the law in that way, I think you immediately understand its implications for journalism, because this is what journalists do. They collect and disclose government secrets. That's not a complete description of what journalists do, but it's a large part of what journalists do. And the United States is asserting jurisdiction not just over American journalists who disclose American secrets, but over non-American journalists who disclose American secrets. And I think even the first half of that is problematic enough, but the second half makes it doubly so. And you can imagine what the results would be if other countries started to enforce their own secrecy laws in the way that the United States is enforcing its secrecy laws in this particular instance. American journalists report foreign government secrets all the time. The New York Times today is full of facts about foreign governments that those foreign governments regard to be national security secrets. And so if you accept that it is within the jurisdiction and authority of a national government to prosecute a journalist for the disclosure of its secrets, period, without more, you've really criminalized journalism globally. And not just criminalized journalism, but criminalized the most important kind of journalism, which is holding governments to account for things that are done in the name of national security. And I think that this issue has been teed up to some extent by the Assange case, but the fact that so many people are hung up on this question of whether Assange is properly considered a journalist, I think has obscured the implications of the case. I said this earlier, but I guess I'll say it again, which is just that it doesn't really matter whether Assange himself is a journalist or not, because he is being prosecuted for the kinds of things that journalists do and need to do in order to inform the relevant publics about government conduct.
Yeah, I would agree with that point by Jameel, that a lot of people, again, it's a red herring to say that Julian Assange, whether he's a journalist or not, because the kind of stuff he is facing charges for is ordinary journalistic activity, like developing a source, keeping that source's anonymity, and publishing classified information and national defense information that has been embarrassing to the US. And you can read classified leaks on the front page of the Washington Post and the New York Times every single day. So it is a huge problem, and people should not be sidelined by the kind of caricatures that are made of Julian Assange. We're trying to differentiate him in some kind of way. But I wanted to ask, again, throw this to all of you, but maybe with Jeffrey, since you actually, it's like fighting with your hands tied behind your back in terms of thoughts on ways that could either reform the Espionage Act, amend it or end it, and in what ways could it be reformed to make it a little bit more of a fair process?
One thing that became apparent to me during my trial is the selective nature of their use of the Espionage Act. If you look at the language of it, it says even holding classified information in an unauthorized manner opens you up to prosecution by, under the Espionage Act. During my trial, we made an attempt to challenge their assertion against me. It's like, well, not that we were trying to get them to go after the journalists in question here, but it's like, if you're charging one person, why aren't you charging the other? Aren't you going by the letter of the law, the way they're using it? But it's selective, how they're using the Espionage Act. It's against, for retaliation more so than anything, in the name of national security. But I also think that just how they've been using it, it hasn't been against anyone who's committed espionage at all since the Obama administration. But for me also on the selective aspect of it and with the rubric of national security, I had also filed, I blew the whistle about racial discrimination at the CIA. I was being stepped over for promotion, giving crappy assignments, despite being a successful officer. And I asked why. And I was told, well, I kind of stuck out as a big black guy speaking Farsi, despite the fact that I'd been all over the world and no one ever suspected me of working for the CIA. So I filed a discrimination suit. The government, CIA, the government, and the courts backed this up, said that if my suit was to go forward, that would be a threat to national security. Black and African American in the United States fighting for his civil rights is a threat to the national security of the US. The courts backed that up, the courts supported it. But then they used the Espionage Act to continue coming after me, to persecute me, and revealed and used the same information that I wasn't allowed to go forward with, but to prosecute me. So that just shows how they use national security as both defense and as a weapon. And then that use as a weapon was, of course, the Espionage Act to go after me. So I think the selective, and it's all whatever way they're going to do to protect themselves or to alleviate the embarrassment from a story that comes out or hide their wrongdoings. And that's what they're using the Espionage Act for, and I think that's the danger.
I agree. It's not a surprise that the Espionage Act has been used to go after people who revealed some of the darkest conduct that was also illegal conduct, like surveillance, mass surveillance of American citizens without warrants, are running a torture program, are running black sites, these kinds of things. But in terms of reforms, there is no public interest defense. Maybe Jameel, could you talk a little bit about how with most laws, there are defenses you can raise and how and why with this one, this law can exist and people are hamstrung to be able to really meaningfully defend against it?
Sure. So, yeah, one really terrible thing about the Espionage Act, or at least about the way the Espionage Act has been interpreted by the courts, is that defendants in Espionage Act cases don't have the opportunity to make a full defense of their actions. They are disallowed from pointing to their motivations as a justification for the disclosure. So if you're prosecuted for leaking classified information, it's not open to you to say, I did leak classified information, but I did it for good reasons. I did it because the public needs to know that people are being tortured in these prisons. You can't make that argument. Nor can you make the argument that the disclosures did not, in fact, jeopardize national security. If the government shows that the information that you disclosed is national defense information, which, again, as Sam referenced earlier has been defined extremely broadly. It's not just classified information, in fact, it's broader than classified information. And classified information is a broad category to begin with. But if the government can show that, then it's not open to you to argue that the disclosure of that information did not, in fact, jeopardize national security, and nor is it open to you to argue that whatever costs there were to national security were outweighed by the benefit to the democratic process or to informing the public. Those arguments, too, are off the table. The consequences that anybody who is considering disclosing information to the public, even information that would show grave abuses of government power, those people really are confronted with the necessity of being comfortable with spending your entire life in prison or your entire life in exile. Like, that's really the future that's awaiting you, and the result of that is that we don't get all of the information that we should have, or one result is we don't get all of the information that we should have. Leaks are undersupplied in our particular, at least in the United States, they're undersupplied.
I'll just jump in on that to connect to a point Jeffrey made about the selective disclosure. I would totally agree that leaks to the public, for the public's right to know about government malpractice, are underprovided, but leaks are habitual, and they're often, the selective enforcement of the Espionage Act is a way that the government in the US can kind of sculpt its reputation and its legitimacy, and people who leak to kind of boost or bolster the image of a government program are never charged under the Espionage Act, and figures who are seen as kind of poster children for government policy are never prosecuted. So the textbook example here is David Petraeus, the general who shared classified information with his biographer. What he revealed were secrets of a higher level than many of the whistleblowers who've been charged under the Espionage Act, but it was not seen as sort of harming the government's reputation, and so he wasn't charged. So this is a kind of overbroad law that is not being enforced across the board because you really couldn't. It's being used very selectively, as Jeffrey said, for very political purposes.
Can I just add one thing? So I think that thinking about the Espionage Act as an instrument of secrecy is actually not quite right, for the reasons that Sam has just said. That really what the Espionage Act does is it puts the same government officials who are in charge of designing and executing national security policy in charge of deciding what the public knows about that policy. We get lots of information, in fact, about national security policy, but it is selectively, it's cherry-picked by the same government officials who put that policy in place. And so the impression that we get about, for example, the drone program is the one that the Obama administration officials who designed the drone program want us to have. And the impression we get about the Bush administration's interrogation policies is the impression that the Bush administration's officials who designed those policies want us to have. And anybody who leaks information that challenges that narrative will be prosecuted under the Espionage Act.
And I just want to say, picking up on something Jameel had said earlier, unfortunately, the Obama trend, it was ironic that Obama, the transparency president, opened up this can of worms by reinvigorating this law. But Trump actually tripled the number of Espionage Act investigations, dusted off a bunch of old ones that were dormant, and that includes of my client, Daniel Hale, who ended up pleading and going to prison, and the one against Assange, which had been just kind of dormant and laying out there, and that Eric Holder, under Obama, had decided not to pursue, but that is now creating this huge crisis of the First Amendment in our country.
Yeah, one point I wanted to make, and you brought up a great name, General Petraeus. When it came over the news that he basically got a slap of the wrist, this is a man who revealed classified information to his paramour who was writing a book. He lied to the FBI, and he just got a slap on the wrist, and I think he still maintains security clearances in the US government. When the news broke of the settlement on his issues, I was sitting in prison. watching that on the prison TV. I mean, if that's not selective use of the Espionage Act, why wasn't he charged with violating the Espionage Act? Well, he was connected. There was no revenge, there was no retaliation they were seeking to do with him. And so I've always wondered, when I see, after my experience, the government using the Espionage Act to go after someone, Assange in particular, it's been quite frustrating for me to see them using it in the same way. Martin Luther King Jr. said, it's our duty to disobey unjust laws. The way it's being applied is unjust. And they're continuing, there's this just cycle. It's like a train starting and trying to stop it. With Assange and some of the legal proceedings, they tout how they will be lenient on him being charged under the Espionage Act. And even the one thing that just disgusted me to no end, they invoked my name as an example of the light sentence that Julian would receive if he's convicted under the Espionage Act. I was livid. You're going to use a travesty of justice trial and under the Espionage Act as the benchmark for what Julian is going to do. But that is just how they feel they can just get away with anything. And the other, quote, lies, or as they say, assurances, that we're secret in the world, U.S. prisons are horrible. But they say, no, our U.S. prisons will take care of you. I had a heart attack in prison. It took a U.S. senator to finally force the prison to get me medical care. Mental health is an issue with Julian. Mental health is a horrible dismissive aspect in U.S. prisons. The response to a counselor, and I was having trouble, was that I wasn't speaking enough, so she was going to put me in solitary confinement, as opposed to helping me, put me in a situation that was worse, because they just don't care. Prisons, U.S. prisons are a little more than human warehouses, and they've become even more so in the aspect of a whistleblower. It's like, this is what you're being threatened with. If you do something or say something that this government doesn't like, we're going to come after you with the Espionage Act and throw everything at you, and we don't have to really prove anything other than we want to prosecute you.
Picking up on what Jeffrey said, I would be remiss in not mentioning Chelsea Manning, who was prosecuted under the military version of this and ended up being imprisoned, including extended periods of time in solitary confinement, and what later was found to amount to torture. And eventually, her sentence was commuted, but only after 7 years of really harsh conditions. So again, what advice would you have for people who are thinking about coming forward about wrongdoing? Maybe I'll start with Jameel, but I welcome all of your thoughts. What are responsible government employees supposed to do, given that they're in whistleblower protection laws, there tends to be a huge carve-out for national security and intelligence?
I don't actually have a good answer to that question. One thing that lawyers who work in this space have been trying to do, or at least civil liberties lawyers and human rights lawyers who work in the space have been trying to do, is get the courts to recognize a public interest defense, so that, I mentioned earlier that right now you can't argue that your disclosures were appropriate or necessary or justified. The courts could interpret the Espionage Act to permit defendants to make those arguments. Or, in theory, the United States Congress could pass a law that amended the Espionage Act to make clear that a defendant charged under the act can make a public interest defense. And my understanding, my expertise is in US law, but my understanding is that a number of other countries do have public interest. I know South Africa has a public interest override in its Freedom of Information Act law, and my understanding is that a number of other countries have public interest overrides for whistleblower cases. And it seems to me that we should have something like that in the U.S. system as well. And and that it's in the interest even of the intelligence agencies to have something like that, because it creates a frame in which we can have an intelligent conversation about which information should be public and which information shouldn't be. Right now, those decisions are made, in the first instance by the whistleblowers, and then, ultimately there's a petition for clemency that's made to the president, and it's a very ad hoc process, totally arbitrary, which whistleblowers are sentenced to long terms, which ones are given clemency, which ones are pardoned, which ones are pursued even when they're overseas. It's totally arbitrary. If we had a system in which whistleblowers could make this defense in court, they were authorized to argue in court that their disclosures were justified, we would have a much more systematic treatment of these issues than we do right now. And I think that serves not just democracy and human rights, but also some of the national security interests of the agencies.
Right. I think in Daniel Hale's case, where he revealed, and in a number of other whistleblower cases where people have actually revealed that the government is lying. Daniel Hale revealed that 90% of the people killed in a period of drone strikes were actually innocent civilians, which contradicted the party line espoused by the US. Other clients of mine have revealed that we were, despite the head of the National Intelligence Agency saying we were not secretly surveilling Americans, not wittingly, in fact, it turned out we were. Edward Snowden is still living in exile because he faces prosecution under the Espionage Act if he were to return here. So this antiquated law not only has been selectively applied, as you said, Jeffrey, but it's been completely politicized. And Bush kind of hinted at it, but it really took Obama, and then Trump has took it off and increased prosecutions 3 times. And then unfortunately, Biden has continued these cases. So even if someone else started them, and he even said, well, those were started under Trump, to try to shed responsibility for continuing the unjust use of this law. But the point is, people are still suffering for it. And I can give a laundry list of people, from Reality Winner to you, to Tom Drake, a whole list, John Kiriakou, Daniel Hale, all these people whose lives have been completely upended because they committed the truth.
Yeah, like I said earlier, talking about administrations, it was the younger Bush administration when I was being investigated. They dropped the investigation. During my trial, the FBI agents revealed that they didn't feel like I did anything wrong because I wouldn't do that and hurt my discrimination suit that was going at the same time. They actually dropped the investigation against me. The Obama administration came in, and no additional evidence, no new evidence, but reignited the investigation and charged me under the Espionage Act. Again, I just relate to that. That's the power of it. There is no way the government can lose an Espionage Act case. All the cards are in their favor, and that's why so many people. They will threaten, we're going to send you to prison forever. And so people plead guilty. People plead to lesser charges or whatever and end up in prison, usually. I'm one of the few that ever went to trial under the Espionage Act. But again, on the selectiveness and how it's being used and how it's even applied, even how defendants are being treated. Mr. Donald Trump was charged with violating the Espionage Act. I spent many hours in handcuffs and behind bars, not a moment for him. I had told some that once I was arrested and finally allowed to return home, I had all these requirements. I had to look for work, drug testing and things like that. And I couldn't find a job, so I always had the probation officers threatening to send me back to jail. And Mr. Trump comes along with the same thing. Well, he's running for president. It's like, if I had known that could be my job to run, I would have run for president after I had been arrested, then that would have satisfied that requirement. Maybe they would have gotten over it, but the whole system is for punishment. But you're not seeing that happen with Donald Trump. And I think that just shows the nature of how unfair and how illegal the use of the Espionage Act is.
Donald Trump actually, ironically, is probably one of the more apt applications of the Espionage Act. But as much as I loathe Donald Trump personally, I would not want to see this act. It's that bad that I don't want to see this law being used against anyone. I can put aside my schadenfreude over the fact that he has kept, retained, possibly traded classified information and mishandled it deliberately, refused to give it back, and has lost track of it completely. I mean, it's such an order of magnitude beyond anything people who have actually gone to prison over one document or faced the rest of their life in prison, like Tom Drake, over information that was not classified at all, but just considered to be national defense information. So, I would love your thoughts on Trump and kind of the optics of this. And I should mention there are multiple other laws out there that can be used to punish the mishandling of closely held government information, but this seems to be the go-to law for the government precisely because you can't defend yourself. So as much as I'm not a Trump fan, I don't want to see it being used on anyone, but I also feel like it's been normalized, unfortunately. And so I welcome your thoughts on that or anything else.
I mean, I'll say about the Trump prosecution. I mean, this is the Mar-a-Lago documents, is retaining classified information without authorization. I think that the Trump abuses here, I mean, it's to be determined whether there's any actual harm to national security that's happened. But there is a definite harm to democracy in Trump's handling of information by not sort of keeping it through normal channels. Part of the problem is that the Presidential Records Act doesn't really have an enforcement mechanism, and so the Espionage Act is a kind of tool that is lying around that's much easier to kind of enforce. But I think that the Trump prosecution should be a reminder to us that actually you do want to have some kind of legitimate system for securing information within democratic governments. And so you do want something like an Espionage Act, a public information law that would make it illegal for individual corrupt officials to sell secrets for cash. But the current law doesn't really work very well for that because it has been abused. And I think back the kind of ironies here of, Hillary Clinton's emails, when that was sort of became public, Obama said there's classified and then there's classified. And given the sort of rampant overclassification in the US government, the habitual nature of leaks, there has to be this kind of selective enforcement. And so the law has lost, I think, a lot of its legitimacy, while both the Trump case and the Jack Teixeira, the young National Service member who had provided classified information on his online gaming networks, is a reminder that you actually do want some kind of law in this place. And so we need reform of the Espionage Act to make it more democratically viable on a variety of fronts.
I think, Jesselyn, I disagree with you about the Trump case. I would not shed one tear if Trump were prosecuted and were convicted under the Espionage Act for the, on the basis of the allegations that have been made, and the allegations seem to be entirely true, right? I think it would be kind of an outrage, actually, if Trump did not serve a significant prison term for these acts because of what you said earlier. In these past cases, we had, often very young people, soldiers, government contractors, risking their liberty in order to inform the public about the worst government abuses. And when they were prosecuted and when they were charged and they were prosecuted, they had no opportunity to make the argument that what they had done served national interest or served the public interest. They were sort of raked over the coals. They were denied any opportunity to justify their actions to the public. And now we have Trump, who appears to have held on to classified information, huge volumes of classified information, knowingly. Not because he believed that the public would benefit in some way, but because he was concerned about his own private interests, right? And I think it would be impossible to justify the actions we've taken in the past with respect to people like Daniel Hale or Edward Snowden or Chelsea Manning, and then not punish Trump for the acts that have been justified here. So I have all the same reservations, or reservations is too mild a word, about the Espionage Act as you do. But I don't think that any of the problems that we've identified in the Espionage Act are implicated or engaged in Trump's case. What he did should be criminal, and he should be prosecuted as he is being. And if the prosecutors are successful in convincing the jury, he should go to prison for it.
Yeah, I think just to jump in on that, the only question with Trump being charged under the Espionage Act, especially considering the history, individuals who have been charged have ended up in prison, whether, like me, went to trial or not. So the only question should be, how much time is Trump going to get in prison? Have we even gotten to that? Is anybody even raising that question? Is that something that is possible? And again, that goes, who knows what's going to happen with his case? Are they going to settle something like that? But the Espionage Act is so powerful. The government doesn't need to, settle for anything less than a full conviction, because they are almost guaranteed a conviction by just invoking the Espionage Act. So, yeah, Mr. Trump should be locked up for a lot of things. I mean, I'm sorry, there was absolutely no evidence in my case. There is tons of evidence against him. How could he possibly defend against that?
I would like to open it up to audience questions, because I think that's really fruitful. So I welcome questions you have. Try not to speechify and instead just ask a question, please. But I welcome your questions.
Hi. My question is a little bit different for your topics, but many whistleblowers, before to make decision, they think about their future. But for example, Treasury Department, they have a whistleblower award program. If someone blowing on serious economic crime about corruption, since 2010, if I'm not mistaken, you're able to make requests for the Treasury Department, and they paid you as whistleblower 10%, up from 10 to 30% of amount, which is their charge of someone who make economic crime or corruption crime. They recently, Danske Bank, which has laundered $250 billion from Russia, Ukraine, and Azerbaijan, they paid fine after 5-year investigation, and the Treasury Department paid $200 million for one IT team member from Danske Bank who's leaked these materials to Berlingske newspaper. From one side, we think it's also motivate other whistleblowers to provide additional leaks, because we believe for economic crime and international corruption generate more problem, even more with the problem which is you mentioned, because it's affected to all member states, and the US economy, which is named themselves transparent economy, they're also huge machine for laundering money. How is it possible to use good practice from this award program for whistleblower who expose economic crimes to also award it whistleblowers like you, who is reported for free? I don't know if it's possible to ask for claims. And do you think whistleblowers like you guys, you should have to apply for any kind of federal governments because you do this for...
I can speak to that for a minute, because the US does have, for example, under the False Claims Act, ways, and Jeffrey can speak to this too, that whistleblowers can eventually recoup money for their disclosures. And the Securities and Exchange Commission has a reward program for whistleblowers. But for government whistleblowers, and that's who we've been addressing, are primarily government employees who blow the whistle. when it deals with national security, there is no kind of reward program. The government claims that there may be a certain amount of whistleblower protection because they want people to be honest, but in reality, when people have reported internally, too often the same people they reported to turned around and referred them for criminal prosecution. So reward programs can work, but it seems incompatible with the people in the national security realm because of the secrecy regime and the overclassification problem that other people have spoken about. It would be amazing to have a reward program for national security whistleblowing, but I don't even know, given the huge amount of secrecy in these cases, how you would ever prove, for example, in Thomas Drake's case, that he did blow the whistle on what was later determined to be a multi-billion-dollar program that was a complete waste of money. There's no civil suit he can bring to try to get compensation that he revealed that and saved the US money. And instead he got prosecuted for it, and even though it failed, there's no recompense for that. Oh, we're out of, oh, are we, it appears we're out of time. Any other quick question? No. Are we totally done? Any closing remarks? We're good. We're over time. Thank you guys so much.
Thank you.